Hello to everyone joining us today. Welcome to the next instalment of our Contract Conversations. And for those of you who haven't joined before, this is a series of webinars being hosted by lawyers across Mills and Reeve to discuss common issues that feature in contractual disputes. In today's session, we're going to talk about some common issues that might arise in a supply chain, and in particular, what are the key considerations and how can companies best protect their positions? Just as a reminder, this webinar is being recorded. Attendees will be sent the slides and the recording at a later date. By way of introduction, my name is Rachel McDonnell. I'm a Principal Associate in the Commercial Disputes team at Mills and Reeve. And I'm joined today by Catherine Noble, who's an Associate in the Commercial Disputes team. And Catherine's practice also focuses on contentious insolvency matters. So I'll pass over to Catherine now.
Thanks, Rachel. So why are we talking about supply chains today? The media has been very quick to pick up on household names that have had supply chain issues. So, for example, at the weekend, there were stories about McDonnell and issues that it's been suffering around traceability within its supply chain. A couple of weeks ago, Pizza Express made the headlines due to a shortage of its bolognese sauce. Apple and Samsung are regularly in the news discussions about issues with sourcing of microchips, and naturally, there have been warnings of shortages at Christmas. It's really easy to be flippant about the problems that are facing large multinational companies and the ones that attract media attention. But the reality is that all businesses will be part of a supply chain, which is by definition the series of processes involved in the production and supply of goods from when they are first made or grown, etc., until when they are bought or used. And service providers shouldn't think that they're exempt. They will actually be part of the supply chain because they're going to need to buy goods in order to operate. So whether it's Brexit or the impact of COVID-19 on international shipping and the domestic market, or the scarcity of raw materials, the impact on businesses is real and it's likely to be ongoing for quite some time. We're not proposing that we can give you answers on how to future-proof your company in relation to supply chain issues, but we do hope to give you some basic points to think about. Given that each supply chain and the contracts that underpin it will be very different, we do recommend that you always seek professional advice from your legal advisor before you take any action. I'll just also remind you that Rachel and I are talking about the position in English law, and given that many supply chains are going to span different jurisdictions, where that's applicable, please take advice on the applicable laws, and also just read your contract to make sure you understand the basic provisions. It really is key because how a contract is interpreted can be quite different depending on the jurisdiction that it's in. As you will see throughout this webinar, and it's entirely appropriate given that this is a contract conversation, the primacy of the contract is key. So always go back to the contract. Before Rachel looks at a basic supply chain and some specific issues that might arise up and down the chain, I'm just going to touch on some overarching issues that you might want to consider. Firstly, as I've already mentioned, always check the contract. Don't just assume that the rights that you would hope to see are going to be sitting in that contract. Secondly, think about geopolitics and how that might impact on your company. So it could be that the supply chain is subject to external pressures like the Sino-American trade relations, or the cost of international steel, or the price of shipping. Even where your company looks like it's contracting purely with companies within England, bear in mind that the subcontractors might be based elsewhere, and that could impact on the supply chain. Which brings me on to my third point about transparency. How much transparency do you actually have in your supply chain? We're going to go on to consider a very, very simple supply chain. But in a multi-tier supply chain, it might not be that easy to see where your suppliers are or to anticipate disruption further down the line. Equally, because you might not have that visibility, you might need to consider things that relate to your environmental, social and governance policies. And that might be particularly pertinent if, for example, your company supplies government departments and you have to consider your sustainability profile. And lastly, in what is by no means an exhaustive list, you might want to consider the links in the chain and whether those suppliers and customers are in financial distress themselves. Rachel and I are both going to discuss practical issues you can think about, and I will touch on the insolvency points more later. In essence, there aren't any easy answers, but we're trying to give you the tools so you can protect yourself as best you can. And I think, as Rachel mentioned, if you do have any questions, just drop it in the Q&A box and we'll try and get to those later. And if we can't do it on the webinar, we'll do it offline afterwards. And with that, I'm going to go over to Rachel.
Thanks, Catherine. You should be able to see the next slide, which is the simple supply chain slide. Stepping back, the benefits of long-term contracts are fairly obvious. They offer certainty to both parties. The seller has a predictable revenue stream for the foreseeable future, while the buyer has more control over costs. But if there is a major change in circumstances, for example, a global pandemic or Brexit or other supply issues, those long-term contracts can become unviable. So let's take the following example on the slide. We've got three parties, A, B, and C, although in practice, the supply chain probably goes far beyond that on both sides. And for present purposes, let's assume that C provides components to B. B then manufactures that product using those components and sells on to A. So what happens if C starts providing components late, or not enough, or not at all? And as Catherine said earlier, the first place to start is what are B's rights under the contract and what do the terms entitle B to do? For example, there may very well be a breach of contract by C. And yes, if there is a breach of contract and that's caused B to suffer loss, then B might be entitled to damages. But really the question is, how is that going to help B right now to get C to perform its obligations? Are there any more practical remedies in the contract? For example, if C is in breach, does B have the right to substitute new suppliers? Or is there some form of penalty-based system, which means that smaller breaches counted cumulatively enable more significant relief for B, or perhaps clearer financial penalties? The nuclear option, does B have a contractual right to terminate? And look, all of those rights would be helpful, but really need to think about the practicalities of those rights. Does B have an alternative supplier lined up? Could B just switch suppliers that easily? Would B just be creating bigger problems for itself down the line? And so it may well be that, you know, all of those rights under the contract may end up just being methods by which, you know, B can exert some more pressure on C to start performing its contractual obligations. And how that's approached depends on the relationship between B and C, how acrimonious it has become, how close it is, whether a formal or informal approach would be most beneficial, and how much pressure is needed to get C to start to perform. Do the dispute resolution mechanisms in the contract provide a route to which you can start to renegotiate? For example, is there principal-to-principal negotiation or escalation provisions? Is there a contractual requirement to mediate? And all of those things are likely to provide a much quicker solution than commencing legal proceedings. All the time bearing in mind that it may well be that C is in some sort of difficulty with performing its obligations. And what you're really thinking about is whether there's a middle ground in which you can renegotiate or reach agreements using those rights under the contract as pressure points. For example, you might defer performance or payments. Look, that's a lot to consider. And perhaps what it boils down to is, if you're reluctant to start legal proceedings, and many companies are, what can you use in the contract to bolster your negotiation position and exert pressure? And so moving on to the next slide, it's always worth in these early stages of the dispute thinking about, and the next one, please. Thank you. It's always worth thinking about what practical tips might be available. And these are general tips that go for every dispute, but all the more so in supply contract issues. So thinking about protecting your position and giving yourself that competitive edge in those early stages should matters escalate. So in terms of practical steps, you can see on the slide there, I've got 6. There are probably a lot more. Number 1, be careful what you put in writing. If matters progress and court proceedings are commenced, then it's very likely that relevant documents, and whether those documents are helpful or unhelpful, will be disclosed to the other party. And as litigators, you have no idea how many times parties get to that stage only to find that someone has written something really unhelpful. and that can change the landscape of the whole dispute going forward. So I guess a bit of a word of warning, before you put pen to paper or start typing, just think, how would this look further down the line? Number 2, speak up about various breaches and keep a record of them. If you say nothing, the other party might rely on that as evidence of you waiving your rights. Keeping records is the best way to produce evidence of the losses that have been suffered further down the line. Number 3, so far as possible, and appreciating that can be difficult at times, continue to comply with your own contractual obligations and to take steps to minimise your losses. This is again all looking further down the track. If things progress, you don't want the other party to be able to say that you are also in breach of your obligations. Or from a mitigation perspective, you shouldn't be entitled to recover losses because you failed to take mitigating steps. You need to take reasonable steps to minimise the losses that you're suffering. And in the supply chain context, that may well look like trying to obtain materials from a third party, for example. Number 4, in any negotiations, be clear about what is and is not legally binding. So if you're letting the other side or the other party stray from their contractual obligations, make clear that this is a time-limited or a one-off arrangement. If you don't, the risk is that it will be treated as a full waiver of your rights going forwards. Number 5, don't run out of time. Some contracts contain specific deadlines for notifying claims or commencing proceedings. There may also be statutory limitations in play. You don't want to come to finally make a formal claim and realise that you've lost the right to do so. And just finally, number 6, thinking about using without prejudice. Now, if you're attempting to settle a dispute, then make sure that any negotiations and or offers are expressed to be without prejudice and subject to contract. And this means that while you are willing to discuss settling the dispute, you don't admit anything or accept any of the arguments that the other side is making, and you don't waive your rights should settlement negotiations fail. And also the key point about without prejudice is that if a matter did fall to legal proceedings, then any without prejudice communications would not be shown to the court. If you get to change the slides. Now just looking at the other side, at your customers. It's all too easy to focus down the chain on suppliers, but what about those companies that you supply? If you're having issues with your suppliers, then they may be causing you issues with your own contracts. Put simply, is B now in breach of its contract with A? And really now you're just looking at similar issues from a different angle. What are A's rights under the contract? Can they terminate? Can they sue for breach? Looking at it from B's perspective, has A committed any breaches that B can identify to use it to help its negotiating position? Again, does A have any practical remedies in terms of substitution, for example? And if you're B, in line with your obligation to mitigate losses that I just discussed, you're going to be thinking about, are there any ways that B can still fulfill its obligations to A? For example, can it use excess stock or substitute products, etc.? And one of the key questions really is, how do you approach A about these issues? And again, that really depends on the relationship between A and B. Thinking through the various scenarios and options and the reception they might receive, and the relationship between the parties and how close or acrimonious that might be. Also bearing in mind that conceding any breaches might leave B more open to claims by A. And I think that's where your without prejudice negotiations will come in handy. But I think that's a little bit about the supply chain contract issues, and I'll pass over now to Catherine, who's going to talk about solvency issues.
Thanks, Rachel. Well, brilliant. Next slide. So firstly, a disclaimer. Mostly by the time I get involved with these matters, it's terminal and we're dealing with the fallout of an insolvency procedure. That said, there are things that companies can consider quite sensibly when a party in the supply chain is hit by distress. I think the solvency issues are particularly worth thinking about at the moment. Obviously, we've kind of coming out the side of the COVID crisis, and measures that were designed to support businesses through that pandemic are largely being removed. So there is a prediction that's going to be quite a substantial and steep growth in insolvencies. So just firstly to consider some issues that relate to companies that are having cash flow or insolvency issues, and the kind of consequences, because obviously where a supplier enters insolvency, the customers can find themselves out of pocket and unable to secure supplies they need, and the supplier is also compromised. So taking our illustrative supply chain, let's consider a scenario where B is having the cash flow issues. Both A and C are obviously going to have an interest in trying to protect their position. Excuse me, if B's cash flow issues become critical, it won't be able to pay C for the supplies, and it might not be able to service contracts to A, especially if C was to withhold deliveries for non-payment. So Rachel's already mentioned many of the things that signal that party in your supply chain is having solvency issues, and also how you might take steps to address those. But what other practical signs can A and C look for? Firstly, what kind of visibility do you have over B's balance sheet? Now, it's very likely this is only going to be available from Companies House, so it's going to be out of date, but it does give an indication as to how revenue compares with debt, and also you can see the historic profile for how that's changed. Equally, if B is late in making its corporate filings, that is very often a sign of either cash flow or solvency issues, or just general turbulence in the management. Are you aware at all whether or not B is involved in any court proceedings, or whether it's subject to a CCJ? Again, they are both indicative of financial problems potentially occurring within company B. And also, what kind of speculation is there in the market over the creditworthiness or viability of the contracting party, in this case B? Quite often that kind of market gossip is quite a good signal for companies that are suffering a little. Once aware of B's position, both A and C might want to take a pragmatic view. As Rachel was alluding to earlier, is it better to flex your contractual terms and maintain the supply chain and sort of protect your longer term future, rather than to allow a key supplier or customer to fail? Equally, if B's position looks terminal, what can you do to protect your position? So Rachel's already looked at termination and renegotiation. It's worth checking your contracts again to see whether or not they have a retention of contract clause. This is particularly applicable in this scenario for company C. Essentially, a retention of title or ROT clause will mean that the seller, so C, doesn't lose title in the goods until B has paid for them. And ROT clauses are often supplemented by additional provisions about how the goods are to be treated, or when you can claim them back or repossess them. They're not an absolute guarantee that C can recover the goods in the event of B's insolvency, because they can be really hard to enforce, but they offer a degree of protection, so it is worth checking the contract. On a very practical point of view, obviously consider the goods if they're perishable and the goods have a short shelf life, and ROT might not be particularly practical within your contracts, because you're not going to get a good price for the goods on resale. Looking at the flip side, if you're looking at company A's position, does your contract with B contain a clause that provides that title passes on the delivery of goods? If it does, then as A, you're going to be entitled to use those goods in accordance with your overall commercial relationship. Now, obviously, if B does enter insolvency and there are debts still due to B, the liquidators or administrators are going to look to recover those debts, but at least you've got the goods and you've got title to them. And then just flipping back to C's position again, just double check your contract to see whether it allows you to withhold the delivery of goods in the event of non-payment. Don't assume that it will do, and don't assume that you have the right just to do that, because if you find yourself refusing goods in circumstances where you don't have that right, you're going to be in breach of contract, and the last thing you want to do is create a cause of action against you. And then if we can move on to the next slide. So in this one, company B has gone pop. But before we consider company insolvency per se, I would just note that directors have duties to act in the best interest of the company. And when a company becomes insolvent or looks like it's becoming insolvent, they have a duty to the creditors of the company as well. So if you as directors or advisors to directors are at all concerned about the viability of your company, please do seek advice. It might well be that actually with the assistance of lawyers and insolvency practitioners or other professionals that the company can be saved as a going concern. So definitely look into that first. So let's briefly consider what questions can arise if B does enter a formal insolvency process. Firstly, what do we actually mean by that? So for the purpose of today, I'm only really going to talk about administrations and liquidations because they are the type of process that you're most likely to come across. But do bear in mind that there are other types of contracts, for example, creditors' voluntary arrangements. The reality is that if a trading partner, in this case B, enters formal insolvency, the position of the creditors, particularly those that are unsecured, is going to be compromised. So if B's entered administration, what kind of outcome can you expect? Well, the administrators are going to be looking to secure a much better outcome for the creditors than in a liquidation, and it actually might be possible to rescue the business as a viable concern. This is often done by way of a pre-pack, but administrators can trade a business and then sell that on as well. Essentially, the viable part of the company is sold to a third party, and then the debt's left in what is generally termed oldco. So if you're in C's position, this is likely to leave you in a relatively good position as you can continue to sell to company B or new company B, albeit that any debts might be compromised, and that will depend on the terms. If a pre-pack or sale isn't viable, then the administrators will still work to a better outcome for the creditors, and it may well be that B trades for a little while. The point, I suppose, for A and B is that your position is compromised because the administration will trigger a statutory moratorium, so you can't commence any kind of legal action against B. Now, you might be able to enforce your contractual rights, but you won't be able to use the courts to get your assistance with that in the usual way. Now, this all sounds very limited, but there can be real opportunities. So by way of an example, some colleagues worked with a manufacturer, so we're going to call it A, and two of its suppliers last year that entered administration. Now, had A not been able to secure the supplies from companies B1 and B2, it wouldn't have been able to run its production lines, and it would have had a really significant impact in terms of its finances and a loss of reputation. My colleagues were able to work with the administrators so that they understood the needs and the requirements of company A and actually which parts of company B or the two company Bs were viable. And it resulted in the administrators effectively trading company Bs and being able to sell the viable business onto purchasers. So new company B is now trading with A, and the supply chain has had minimal disruption. So whilst A was put to some inconvenience and expense, it was able to minimise the impact on the supply chain. And it's also had a knock-on effect because effectively company C hasn't had such a big impact either because new company B can still purchase from it. And just quickly on liquidation, it is generally a last resort. So company A might force company B into liquidation if it's not able to supply its goods and there are debts accruing, or actually the company directors might accept that the company is insolvent and place the company into voluntary liquidation. Realistically, the liquidators will work to realise assets for the benefit of the creditors, but B won't be a viable concern, and it's going to be quite difficult probably to recover anything. So you're going to be looking at pence in the pound if indeed anything is payable. So A and B could both prove in the liquidation, but there's no guarantee they're going to get anything out of it. I would just say, and whilst this could sound a little macabre, it could be an opportunity for A or C to purchase assets from the liquidators. So you might be able to help your business that way, even though you've lost a supplier in B. And I'm just conscious of time, so just quickly, a couple of points to note. A lot of contracts, particularly those that were drafted before 2020, contain a clause which provides for termination in the event of party insolvency. Be careful of those automatic termination provisions. the Corporate Governance and Insolvency Act, or CIGA, means that they're not automatically effective. Now, in practice, a liquidator is probably very happy not to incur future liabilities by accepting the delivery of goods. But an administrator might be in a different position, and they might actually require you to supply those goods in order to keep Company B trading. As such, and returning to the theme of today, keep channels of communication open and talk to office holders. And then secondly, and this is something that I do see quite a lot, just because Company B has fallen out of the chain, don't assume that there is a relationship between A and C. A cannot make C deliver its goods to it, and C cannot enforce a debt that was due from B from A. So just bear that in mind. You might be able to come to a perfectly good future relationship, but you can't impose one backwards. And then if we could have the next slide, please. Just some very practical steps, kind of moving slightly away from the insolvency point. But you might want to consider now how much visibility you have over your supply chain and how well your customer and supplier contracts marry up. So Mills and Reeve and other law firms will offer a review of your supply chain contracts, and it's essentially a paper-based comparison of your terms and conditions, but they allow you to help identify liabilities and vulnerabilities within your supply chain. As Rachel mentioned earlier, think about whether or not you can diversify your suppliers and or customer base. Long-term contracts are great because they offer certainty, but you can become too dependent. So just think about those options. Particularly if you're Company B and you're having the cash flow issues, look to see whether there are any finance options available. So you might be able to get a finance option through a bank or a finance institution, but equally, some of the bigger chains and manufacturers have their own financing options. So for example, Jaguar Land Rover and Siemens all offer finance for their suppliers, and that can help both alleviate immediate cash flow pressures and also engenders loyalty within the group. And then just very, very finally, consider whether or not there are any sector specific options or practices that you can consider and implement within supply chain. So for example, both Network Rail and within the grocery code, there are practices which are about payment and require people within the supply chain to adhere to those payment provisions. So it's just worth considering whether or not anything like that applies to you. And I think that is it from me. Just going to see if there's any questions, which there aren't. Did you have anything else you wanted to add, Rachel? I'm just conscious of time.
Yeah, I think just one sort of question in my mind that we often get asked is whether you could just go out and get an injunction requiring a party to perform the contract. And just very quickly, I think on that, I think in theory, maybe, obviously if they're in difficulty, then getting an order requiring them to comply might not help. And a bit of a health warning around that. Get an injunction, you need to commence proceedings and then seek an injunction on top of that. You also have duties to give cross undertakings in damages, and it's very much at the discretion of the court. You have a number of different elements to prove, including that damages aren't an adequate remedy. So I just wanted to touch on that briefly because it's a question that we get asked quite a lot. I guess due to time, we'll probably finish there and follow up separately if we need to. If you have any further questions, please do get in contact with us. And if there are any topics you'd like us to cover, then do let us know. We'd also be very grateful if you could fill in the 2 questions on the poll at the end of the session. The next contract conversation in the series will be on the 14th of December, which I understand is a contract conversations Christmas quiz. So we hope you're able to join us for that. Thank you very much for your time.